Like thinking of these types of themes in the background. So law tech can make legal systems more efficient by automating different tasks and therefore cheaper and more accessible. And predictive law tech and criminal law has received much attention, but it's also used in civil law, a facet of legal analytics, which I'll get into. And then the background philosophical socio-legal questions had about codifying law and giving AI the authority to make value-laden decisions. Law tech. So the big question with this is how do we ensure there aren't trade-offs for the quality of the justice system that we have while increasing its accessibility in the age of law tech? Okay, so this is legal analytics, and I think the conversation's a bit quieter because they're very hard to pin down when it comes to regulating them because they have so many services. So they can use things like billing data and to provide administrative insights or pricing consistency for a firm, so like the kind of back end work. But they can also provide, predict the likelihood of success, the duration and cost of a particular case, and you can do so by profiling the judges, lawyers, involved. And also from those predictions provide litigation strategization tips. So things like which case precedents to reference if a particular judge references it a lot. So a lot of understanding about the judge's form. So these come with many benefits in green and risks in red. So they can optimize the litigation strategy. They can provide the edge of experience to small law firms by having the form of the judge a bit more readily available. So more experienced lawyers may have had more time in front of the judge. It can increase the success rate of law firms, which comes with the flip side, and can make legal pricing more consistent, which is a public value of a more predictable legal service. It can help optimize firm management from the back end, and the profiling provided by the judges about the judges is valuable for academic research. So some of the risks, the usual, it's historical data sets, any historical prejudice of socioeconomic status, race, ethnicity has been baked in. So things like a lower settlement amount or saying you should settle out of court when you would pursue trial in some cases might be a form of disenfranchisement. The opaqueness of the algorithms and the trade secrets of the people that develop them have a twofold effect of being able to understand why legal decisions are being made, especially because AI is they don't use legal concepts in their reasoning, so you don't actually know what weight particular variables have and why. So the flip side of increasing the success rate of law firms is that if there are historical biased data sets, if you disincentivize risk-averse clients by having a lower prediction of success, if it's for a disenfranchised group, could perpetuate a form of disenfranchisement. As well, inherent to the natural language processing that's underlying these technologies, they're kind of limited in some of their linguistic interpretation abilities, so they could have different conclusions for the same things. Even an Oxford comma could confuse it, which they're known to do. Okay, actually, this one's out of order. So these are some of the new challenges. One that's pretty interesting is that it poses new issues for negligence in the legal field. So how and what type of precautions should be taken as a lawyer when using these types of services. The rights of judges and lawyers as data subjects, like this is the EU part. So what kind of consent is needed to begin profiling? Do you need consent? Is it necessary? Is it public service? Those types of things. And also, how necessary is the knowledge of the judge's form in particular for providing a good service for your clients, which I think is pretty compelling, especially if the judge's form has an overwhelming impact on the outcome of the case prediction, as well as the inherent susceptibility of bias and inconsistent cost-benefit analyses of the case, like the predictions of the case success. So then, actually, we should go get that. Oh yeah, that's a little bit. They're out of order.
You have to use the keys on the keyboard.
The back end. Oh, okay. Well, this is the existing policy. So we've got GDPR, which is the one I've had to lean on most heavily because there are some other gaps. France has banned judicial analytics in Article 33 back in 2019, which is quite controversial because it was a very broad policy that basically criminalized a core tenet of legal research. You could be punished up to like 5 years in prison if you profile a judge. And then in the EU AI Act, so they've made a specific effort to outline the AI systems that are used to assist judicial authorities. So use terms like researching, interpreting facts, and applying the law. So there's some facets of legal analytics that actually do satisfy it, kind of, like they're not completely involved in direct application of the law, but legal advice. But there's the other side that also goes in the lower risk exempted parts in the EU AI Act, including e-billing and e-filing, all the administrative tasks that don't affect the case. So because it's straddling this the EU AI Act and because of the background controversial ban on judicial analytics, like how do we approach this? So the one aspect of legal analytics that I got to differentiate it from the rest is the fact that it can profile and it profiles judges. So that's where I lean pretty heavily on GDPR. Okay. So I combined things like the rights of data subjects and judges, lawyers, and clients, the discussions surrounding France's ban, a lot more aspects of GDPR to basically say that it would require a mandatory data protection impact assessment, with some attention drawn to the fact that the profiling that produces legal effects is kind of tricky because you're profiling judges, but the legal effects are on the clients. So putting all of this together, then that's where I established that data protection impact assessments should be mandatory for legal analytics without banning them completely. And so what is a data protection impact assessment? It's basically you outline the legal analytics themselves, the risks, how you mitigated those risks, whether or not it's a necessary process to begin with, and then you update these types of things annually. And so why is it beneficial? It provides more transparency measures for lawyers, judges, and clients, just to know what's going on and why. You're allowed to compare, you can conduct comparative assessments between different legal analytics services because different companies will create different algorithms, and if they come up with different responses, you need to know why. It could allow for greater tractability of liability because it basically outlines what tasks someone is responsible for and why. Usually when you're choosing AI, something liabilities are triggered to establish, especially if we involve the responsibilities of the developer. So mindful and fluent consultation with legal, academic, and data protection professionals, but also just the approach to DPI gets people thinking, what types of risks, your interpretation of what you value in law, valuable in the legal practice, all the philosophical stuff you get to weigh and assess. Also be proactive because these are conducted before legal analytics are even used. So you're compliant and proactive, and you can still use the technology. So what's next? I will be establishing the sector-specific DPIA. So if any of you are interested in interview, please let me know. And we'll be using best practice recommendations. Because DPIAs aren't, a silver bullet for everything. There are potential shortcomings that it could just be a checkbox for compliance, but you want to make sure that they're actually taking the stuff on board. So one of the things I was discussing is providing different approaches to the regulatory guidelines and the ethical promises of the lawyers themselves. What type of responsibilities do they assign and guys they have, and other things like notifying the judges that they've been profiled, even if they don't have to consent to their data being used, as well as potentially mandatory publication of the DPIA for public accessibility. And then I work with another nonprofit for humanity that creates audit criteria for AI systems. So if this works out, I'd dig in some more for the practical elements of it. And so these are the conclusions. They might balance the risks with the benefits of legal analytics. The profiling facet of legal analytics in particular may render the service high risk under GDPR, but also in the EU AI Act. And if you want to make sure that they're hammered in as a high risk EU or AI system under the EU AI Act, maybe Section 40 that mentions all the risks for judicial administrative systems could include something like predictive analytics, but that's only from being very ambitious. And then after consulting with previous people before this, the one thing that we really emphasize is that training is required for the lawyers using legal analytics just to understand what's going on. So that's just the definite concrete first step for how to do this as well. So here